This is a message that I would like to put to the federal government in Australia regarding the last or recent High Court decision concerning asylum seekers coming from Sri Lanka and possibly other parts of the world. I believe if the government doing its job properly, it's easy to get over this hurdle for the best interest of all Australians. The ruling of the High Court said or stated to the effect that it cannot mix a criminal past of an applicant who came whether legally or illegally and apply for refugee status in Australia. The ruling said cannot mix criminal issues, criminal past with immigration laws. And that was possibly the assessment of the security or the ASU, I'm not sure, whatever the case is. The point that I need to raise that a High Court in Australia is the ultimate justice arena to resort to, and its decision is binding to all other courts and tribunals in Australia. So it's a lock, cannot go anywhere after. But it doesn't prevent the applicant, which is the federal government, from applying to the High Court for the full bench to have a review in that ruling or decision on the following grounds. First, there should not be contradictions regarding principles of law that came from the High Court in the past. And regarding the High Court rejecting criminal issues and immigration laws, and she said, and I withdraw that, and said cannot mix them, and immigration laws is different, and the whole application of asylum seeker is going or tampering with immigration laws. In the past, we have to look at a case called Purvis case, which is disability discrimination case, being decided by the High Court of Australia. The facts of the case, in short, it was about a disabled child in the school, and he has mental issues and documented as a disabled child, and the school ruled out to repel the child from the school. And in the argument, the school or the perpetrator or the applicant to the High Court, or possibly it was a respondent, I'm not sure, but the school said there was other issues from the child which was criminal in nature, which was very funny. A child mentally disabled, it happened that, and these are his conditions, was incited or provoked, or it was his perception, doesn't matter, and he hit or tapped one of the teacher's ladies on her legs with his hand and some other similar conduct, and it was raised as a criminal conduct to exacerbate the case against the child. And the High Court by majority ruled out that the child case was defeated, and the decision was in favor of the school against the disabled child. While I believe one of the justices, possibly Justice McHugh, in my views, he said the right reasoning when he said these are disability laws. It's totally separate from criminal conduct, and if the High Court is to deal with it, it should be referred to the Parliament for the integrity of the disability laws and to enable the operation of the Act regarding disability only. Criminal issues are different or should be dealt with in different criminal jurisdiction and not in this court, but he was from the minority and the court by majority, I believe, 2-1. I'm not sure, or 3-2, ruled out against the child and considered his, between the brackets, funny accusation of criminal conduct, but it was an issue that been taken into serious account, that his criminal conduct participated to the defeat of his case. So the High Court related criminal conduct to totally different arena or different area of law, which is disability law. If we want to apply that to the recent ruling, the High Court should apply the same, because it is a principle of law, regardless the difference in the facts were different, but it's a principle of law, and one of the principles of law, the High Court decisions should be in harmony and not contradicting each other. Actually, this case is still a good law, and that's different argument where that case should be set aside and the Parliament should address that matter, but it is a lock for any appeal to the High Court. It cannot be appealed any similar case because of this case, but that's different issue. Now the issue is, I'm talking about the recent ruling of the High Court where they said criminal is different from immigration. Criminal laws or criminal past of the applicant totally different from the immigration, and the ruling was in favor of the applicants. If that is the case, then it has to be raised how in the past the High Court said something different, were involved and accepted the argument of a criminal conduct with totally different area of law, which is disability law, and defeated or ruled against the child case, the disabled case, accepted to that argument of the criminal conduct, and now rejecting this argument of the criminal conduct where a person possibly came to Australia and his hand stained with blood. This is very important for the federal government or its